Hello everybody, myself Tanvi and I'm here to talk about a new topic of land and real estate law. The name of the new topic is Land Acquisition Act in depth. In my previous video, I've already covered in just about Land Acquisition Act. Now here in these videos and upcoming videos, I would talk about Land Acquisition Act in detail, in depth. Now, I have divided this topic into number of subtopics. I would discuss what is land acquisition and how land acquisition, what is the relevance of Land Acquisition Act 1894, what are the key problems with Land Acquisition Act 1894. Uh, then I would also discuss Land Acquisition Act 2013, salient features of Land Acquisition Regulation and Recompensation Act 2013, and important provisions of the Act. I would also discuss procedure of land acquisition and what is the relevance of Land Acquisition Bill. What are the pros and cons of the bill, and comparison between the bill with the 2013 Act and 1894 Act, and the recent amendments. Uh, all these topics are divided into a couple of videos. In the first video, I will talk about what is land acquisition and and I will also talk about the Act 1894 land acquisition and key problems with reference to the same Act. In the next video, I will talk about the present Land Acquisition Act 2013 and salient features of 2013 law. I would also talk about important provisions of the Act and procedure of land acquisition. Then in the next video, I will talk about the Land Acquisition Bill, pros and cons, comparison, and recent amendments. So, if I talk about land acquisition is the process by which government acquires private property for public purpose. Till 2013, land acquisition in India was governed by Land Acquisition Act 1894. Now, land acquisition, what are the key problems with reference to land acquisition in the year 1894? As uh, I would just I would just draw your attention towards the year of the previous act, that is 1894. This was the time when Britishers used to rule India, and this law was made by the British government only, and they asserted all the rights to the government to acquire any land, that too without compensation, without any alternative benefits, because of the present act, there were a lot of people who suffered because of acquisition process. And what are the key problems with Land Acquisition Act 1894, which we will discuss now? The government could acquire any land as it wishes to in the name of public purpose. The term public purpose was unambiguous and open to executive discretion. So poor people's land was acquired at throwaway prices in pretext of government project. So in right now in 1894, the concept of public purpose was not defined at all. But now in 2013, the concept of public purpose is well defined. There are a lot of case laws of the judiciary has given a proper liberal interpretation to the clause of strict interpretation to the clause of public purpose. And the main aspect or the main reason of land acquisition have to satisfy the clause of public purpose. So earlier, when 1894 law was prevailing, the concept of public purpose was very ambiguous, was very confusing, and the executive had a discretion to interpret it, to open it, to expand it. The judiciary had no alternative or no power to give a different meaning to the concept of public purpose. Therefore, the poor people's land were actually uh, were exploited, and they were not given proper compensatory amount with respect to the land taken away. Sometimes such projects were started and the same cheap land was resold at higher price to real estate developers without building anything for public purpose. So these are the problems which actually faced by the previous act of 1894. And in terms of safeguard, There is no real appeal mechanism to stop the process of acquisition. A hearing under Section 5A is prescribed, but it is not a discussion or negotiation. The views expressed are not required to be taken on board by the officer conducting the hearing. So there were no concept of public hearing. The public opinion was never taken into consideration, and the concept was not a discussion. It was just merely announcement of the decision taken by the government and taken by the higher authorities. But now the concept of public hearing and public discussion is majorly taken into account, and everybody is strict about public hearing and hearing the masses what problems are they facing because of acquisition. The next problem which the 1894 Act lagged in was silent on resettlement and rehabilitation of those displaced. Now, before talking about this topic, I want to discuss the meaning of these two terms: resettlement, rehabilitation. Resettlement is once a government is acquiring a piece of land which is being owned by some people. The government is mandatory, or government out of obligation, they will have to resettle the people who've already settled in the area where which has been acquired. So the concept of resettlement means shifting them to a different area, settling them to a different area. And rehabilitation means to provide them a proper rehabilitation centers of those who are displaced. And the problems faced by 1894 Act was there was absolutely no provisions in the law relating to resettlement and rehabilitation of those displaced by the acquisition. The next problem which was faced by 1894 law was urgency clause. This is the most criticized section of the law. The clause never truly defines what constitutes urgent need and leaves it to discretion of the acquiring authority, which is the most, and this particular clause is the most talked about clause in 1894 law. The urgent need and discretion of acquiring authority would never taken into consideration. The other problems were low rates of compensation. The rates paid for the land acquired are prevailing circle rates in the area, which are notorious for being outdated and hence not even remotely indicative of the actual rates prevailing in the area. Litigation, even where acquisition has been carried out, the same has been challenged in litigations on the ground mentioned above. This results in stalling of legitimate infrastructure projects. So these are the problems which were majorly faced by the 1894, starting from the public purpose clause and demerits of not having public purpose clause. Then there were no safeguards with reference to public hearing. The act was silent about resettlement and rehabilitation of those who are deeply displaced. The concept of urgency clause, which is the most talked about clause in the act, was not. Was not even considered valid. The rates of compensation was very low, was extremely low, and the concept and the litigation, it was a challenging step to litigate or to file litigation against legitimate infrastructure project, which is a very big task. These are the real pictures of those whose land was taken by the government on the basis of 1894 laws, and they actually wanted a fair compensation, a fair settlement of a fair grievance with reference to their land being acquired by the government. These are the real pictures. I think you can see here in the entire screen that there are three pictures which I eventually want to discuss. Eventually want to portray the pains, the turmoil which these landless people used to suffer during 1894 laws. In the next video, I will talk about the new LARR Act 2013, which surpassed 1894 law, and it majorly was enacted to support poor landowners with reference to acquisition by the government. What are the steps they have taken? Whether these problems were being solved by this particular law? We will discuss all that in the next video. Thank you so much.